For thousands of Greater Clevelanders, RTA is more than just transportation.
I use RTA for everything.
It's a lifeline.
I use it to get to work. I use it to go to Walmart to pick up my prescriptions. I use it for everything.
Lauren Brock told us she needs every penny she earns from 2 part-time jobs, in part to help pay her insulin bills because she's diabetic. So when the cost to ride the bus went up in 2016 by $0.25 per ride and by $10 for a monthly pass, that affected Lauren.
It makes it really hard to save money when I'm constantly buying bus passes because I need it.
Likewise, Edith Dunlap, a retired federal probation worker, told us she travels almost exclusively on RTA, but in 2016, RTA eliminated the portion of the Route 37 bus that Edith used to rely on every week.
It made where I could get to where I wanted to get in 8 minutes. Now, the same thing. It's almost an hour because I got to go 2 different routes.
RTA said it had to implement all the roughly 20 route cuts and reductions and all the fare increases because it faced a roughly $7 million shortfall. Before the route cuts and fare hikes hit, the head of RTA, Joe Calabrese, said they would only be put in place if they were absolutely necessary.
Cutting a bus route for someone is like taking their car away. If they can't get to work or can't get to school, it becomes very serious to them. So it's a very personal issue.
But where did the financial shortage that may have contributed to the cutbacks and the fare hikes come from? An internal audit summary obtained by the I-Team reveals RTA's own auditors questioned nearly $2 million in prescription payments made on behalf of some employees. RTA is primarily self-insured, meaning it covers a lot of its health care costs with its own dollars. Those dollars come in large part from a countywide penny sales tax and bus and train fares. Money is even tighter now because state funding is drying up. Against this backdrop, we showed what we uncovered about prescription payments to a public transportation advocate and first to Cleveland's longest-serving city councilman, Mike Polensek.
That's absolutely incredible. Not only incredible, it's like shocking.
Wow. That's unbelievable. That's unbelievable.
Let's start with what's known as fluticasone propionate. The brand name is Flonase. It's a nasal spray for allergies that's now available over the counter, though you used to need a prescription. The summary of a confidential RTA internal audit reveals that the agency paid for prescription Flonase-type medications in 2 ways. The first way was what you'd expect, what RTA calls conventional. It's the second way that RTA's internal auditors questioned. During the 14-month period the audit examined, RTA paid for 774 prescriptions of the medication through the conventional means. The total cost was just over $8,200, or $10.59 per prescription. Over that same period, 103 prescriptions were filled through the question means at a total cost of ready over $1.5 million. That works out to over $14,600 per prescription.
14,000 smackaroos for Flonase?
How is this even allowed? How does the bureaucracy let this happen?
Although Flonase-type prescriptions make up over $1.5 million of the nearly $2 million in question payments, the audit summary shows RTA paid extraordinary amounts on every one of the 15 drugs listed. Clonidine HCl is a blood pressure medication. A brand name is Catapres. Through the conventional means, RTA paid for 88 prescriptions at a total cost of $119. That's just $1.36 per prescription. It paid for 3 prescriptions through the question means at a total cost of over $10,600, or over $3,500 per prescription. Gabapentin is a nerve pain medication. The conventional way, RTA paid for 414 prescriptions at a total cost of about $5,800, or $14.19 per prescription. Through the questioned way, RTA paid for 19 prescriptions, total cost over $53,000, or more than $2,800 per prescription. All total, RTA's internal auditors questioned 179 prescription payments at a total cost in excess of $1.8 million. If I were to tell you they wasted about $2 million buying prescriptions that should cost a few thousand, what would you think?
I'd be highly irritated.
I think it's unfair for them to pass that because of what they're doing. They pass it on to us.
Pass it on, riders say, in the form of higher fares and reduced routes.
I work for everything I have, And if they're just throwing around money like that, why are they in charge?
I think it's time for the board to step up and do their jobs and hold staff accountable for these mistakes. Because in the end, they are responsible to the voters and to the residents of Cuyahoga County to ensure that this system is run properly.
RTA officials declined to do an interview to explain what happened here. They say they won't do so because of a pending investigation. Meantime, the news about these questioned prescription payments is coming to light as RTA's budget appears to be growing ever tighter.
We cannot have this type of waste with our transit system that people depend on every day.
In the short term, due in large part to state cuts, RTA is trimming certain routes, including reducing the frequency that the Route 30 bus runs through Councilman Polenczyk's Collinwood ward. A proposed fare increase to $2.75 a ride that was to take effect this August is now expected to be put on hold by RTA's board for further study.
When you talk about a rate increase next time, what about the $14,000 bottle of Flonase?
Polenczyk says he respects RTA's leadership, but something needs to change.
If you keep jacking up the rates, then what does RTA mean? Return to the automobile.
But many people may not have that option, which is why the prescription charges anger them so.
If they aren't managing the money well, then we're the ones who have to pay for it. I have to give up more of my money that I'm working hard for. That's not fair on me.
Bill Scheel, Fox 8 IT. For most of us, stepping onto an RTA bus or train is easy. RTA's paratransit system exists to allow people with disabilities to more easily access public transit. But the disabled weren't the only ones getting rides in the paratransit vans. Internal RTA documents stamped confidential say, quote, dispatchers and operators abuse the system to transport family, friends, and co-workers. Transport where? To entertainment venues, shopping, medical appointments, to complete personal errands, transporting children to and from school, and to the airport.
Literally just breaks my heart.
Marvin Randleson grew up riding RTA. He's now a public transit advocate for All Aboard Ohio.
I am really, really frustrated of the inability of RTA and their board to run a high quality system free of scandal, I guess that's what you could call it.
We reported back in 2016 that 3 RTA workers faced charges related to the abuse. But confidential RTA documents obtained since by the I-Team show the problem was more widespread than just those 3 people. We told RTA we wanted to discuss the paratransit issue. RTA set up an interview with Dr. Flounce Caver, who last October was promoted to Chief Operating Officer.
I am ultimately responsible for all of the service provided at RTA, which includes the bus, rail, and paratransit services.
Dr. Caver told us RTA conducted an investigation after employees reported the abuse in 2015.
3 of our employees were terminated for, in fact, providing rides that were not sanctioned under the ADA law.
And did a further investigation reveal that the problem was more widespread than just those 3 employees?
No. The FBI indicted 3 individuals, and those individuals pled guilty for it.
So the documents that I have that say there were other dispatchers who gave rides and that those were valued by RTA in excess of $100,000, those are incorrect?
I'm not sure of those documents.
Do you mind if I show it to you?
You can.
We then showed Dr. Caver a 4-page classified RTA document.
And if you look at the last paragraph on the last page is what I'm referring to.
That paragraph says in part, quote, other paratransit dispatchers scheduled hundreds of rides for family and friends. Later in the same paragraph, RTA's internal audit department wrote, quote, we estimate the cost of the rides provided to family and friends is $117,563. Dr. Caver read over the documents and then responded.
So I do have it here. I do see this here, but I have not seen this audit.
Were you aware that there were more than 3 people involved?
I was not.
Are you able to address the broader problem at this point, or are you not?
I'm not able to address the broader problem, but I am able to address that there were 3 individuals who were indicted by the FBI and the prosecutor.
A few days later, RTA sent out an update to us that said in part, the FBI decided to investigate the ringleaders, and those 3 pleaded guilty in 2016. The total loss was just over $120,000. Over a 12-year period, there were over 2,200 unauthorized rides. RTA says in that time frame it provided just over 7 million paratransit rides and that no paratransit riders were denied service because of the abuse. RTA described trying to find the fraud as, quote, like trying to find a needle in a haystack. Dr. Kaber says RTA now has newer systems in place that can actually search for possible fraud.
An example would be patterns of individuals who have not taken trips in a certain time frame, right? And so that then allows us to key in and find out why aren't these individuals taking trips.
Because in this case, in one of the three people you mentioned, somebody was using the card of a person who was deceased.
Yes.
The internal documents do say, quote, one customer account was used to book many trips for 14 months after the customer died.
A complete management audit of RTA is necessary at this time to ensure that everyone is doing their job properly and the proper controls are set up within the organization to ensure that the public dollars are being spent properly.
The news about the paratransit system comes at a difficult time for RTA. Ridership is down and state funding is being cut. This week, RTA's board voted to draft tax hike proposals to put before voters, either a sales tax increase or a property tax hike. But how RTA spends its money has been in the news lately for all the wrong reasons, starting with an I-Team investigation back in March.
14,000 smackaroos for Flonase?
In March, the I-Team revealed that other internal confidential documents showed RTA's own auditors questioned over $1.8 million in prescription payments. That included paying for 103 containers of the nasal spray Flonase at an average price of over $14,000 apiece, for a total cost of over $1.5 million. Taxpayer-supported RTA is self-insured, meaning it pays for most of its own insurance.
You cannot justify that to anyone who steps onto a bus or a rapid car. You can't justify those numbers.
RTA later said it was the victim of a nationwide insurance scam. County prosecutors investigated but recently refused to charge any bus drivers, citing insufficient evidence of intent to defraud by the employees. The U.S. Attorney's Office will neither confirm nor deny the existence of a federal investigation. RTA had said in March, because there was a pending investigation, it wouldn't comment for our initial report on the prescription insurance payments.
That report opened the eyes of some board members that they have literally a legal responsibility to manage this agency.
Then, less than a month after our report, RTA's longtime board chairman, George Dixon, suddenly resigned over an insurance issue. An audit found Dixon had improperly received health insurance benefits for 24 years, totaling over $1 million.
The board is committed to the taxpayers to make sure that this never happens again.
Regarding the questioned prescription payments that included Flonase, RTA's own timeline says what it terms a scam went on for more than 2 years. RTA told us the abuse of the paratransit system spanned 12 years, and it said the Dixon insurance issue went on for 24 years.
Is it fair to ask who's minding the store?
I think that's a valid question. Absolutely a valid question.
Ann Randallson says with state funding drying up, local voters must have faith in RTA before they might agree at some point to give the agency more tax money.
They have to make those changes that are necessary to restore those faiths. If that requires major shakeups in management or major changes to how they do business, they have to do it. Whatever it is, they have to get to that place where the voters feel like they can support public transit again.
Bill Scheel, Fox 8 I-Team.
At its meeting earlier this week, RTA's board announced that its general manager, Joe Calabrese, would leave that role earlier than expected.
How RTA spends public money is ultimately the responsibility of the RTA board, including what the board spends on itself. And recently, RTA spending has been called into question. First, by an I-Team investigation that revealed, among other items, that RTA bought 103 containers of the nasal spray Flonase at an average cost of over $14,000 apiece, for a total expenditure of over $1.5 million. RTA later said it was the victim of a nationwide prescription insurance scam, though county prosecutors declined to charge anyone, and federal prosecutors won't say if they're investigating. Then, the longtime RTA board president George Dixon was forced out after an investigation revealed RTA spent over $1 million on health care benefits for Dixon over 24 years that he wasn't entitled to.
The board is committed to the taxpayers to make sure that this never happens again.
The RTA board is comprised of a mix of elected local officials, high-ranking public employees, and private civic leaders. The new president, Westlake Mayor Dennis Clough, told us each member has accepted payment for being on the board. RTA says that's $500 a month for Clough as chairman and $400 a month for other members. But at least for a couple of the board members who hold public jobs, that raises a question. Mike DeWine is the Attorney General of Ohio.
Public employees clearly under Ohio law cannot be paid by two different public entities for the same hours. It's kind of a basic concept. You can't get double pay.
Well, unless you're an elected official. We'll get to that in a moment. Two RTA board members, Cleveland City official Valerie McCall and Cleveland Schools official Leo Serrano, are public employees but are not elected. The Attorney General says as a general matter, public employees can't get paid separately by public boards unless they take vacation from their job for the time they spend working for the board.
Basically, you clock out from that job and go to the other, and that's probably not a problem because you're not getting paid, double. But getting paid double, it's against the law, it's wrong.
In a statement, RTA says Serrano and McCall are currently not being paid, and records confirm that. The agency says it began investigating the matter before the I-Team started asking questions. 2 weeks after our initial inquiry, RTA sought an opinion from the Ohio Ethics Commission to interpret the law. It says those responses are currently being reviewed. But regarding elected public officials who serve on the board, the law is clear. They can get paid both by their cities and by RTA. It is a different standard for public elected officials versus public employees.
Yes.
Case Western law professor Andrew Paulus says he doesn't agree with the reasoning behind having two standards.
Would you say it's a double standard?
Well, I think there's a lot of doubling going on here, both in terms of the standard and in terms of the dipping.
Paulus says the reasoning is based on the idea that elected officials, such as Mayor Clough, Mayor Wheelo, and Newburgh Heights Mayor Trevor Elkins, aren't paid by the hour or even the day, and that they are accountable only to voters.
That ability to respond through the polling booth is deemed as a policy matter to be an adequate check on double dipping. So yes, there's a double standard. Yes, it's unfair, but the thought is we can address that if it's important to us at the polling place.
Some public boards choose not to pay their members. Major universities such as Kent State and Ohio State are two examples. Still, elected public officials can legally get paid twice by taxpayers for serving on a public board. Does that make sense? That's a good question. Bill Scheel, Fox 8 I-Team.
And good morning to everyone here.
When Academy Award-winning actress Octavia Spencer delivered the 2017 commencement address at Kent State, Fox 8 made a public records request for her speaker's contract. Kent State, as a public, taxpayer-supported university, readily complied, showing that the university paid Ms. Spencer $100,000 plus first-class airfare. That amount caused some controversy.
I don't really know if it is worth it because that is a lot of money. So I feel like it is fair that they do get paid, but that amount is pretty intense.
Kent State said the publicity generated, the fact that it used donated funds to pay Spencer, and that it united all its campuses in one commencement made Spencer's appearance worth the $100,000. A few months later, Octavia Spencer spoke here in a question and answer format at a fundraising luncheon in Cleveland for the Cuyahoga Community College Foundation. Fox 8 made a public records request of Tri-C for Ms. Spencer's speaker's contract, but this time trying to find out what she was paid led to a court battle that we fought for well over a year.
Is this case one of first impression for the state of Ohio under that Public Records Act?
The fight led us here to Ohio's 8th District Court of Appeals in downtown Cleveland. Judge Patricia Ann Blackman was referring to a relatively new provision in Ohio law that we employed. It allows anyone to file a one-page complaint, required by law to be handwritten, with Ohio's Court of Claims when their public records request has been denied.
It's supposed to be easier for, members of the public, journalists, to go to the Court of Claims and enforce their public requests cheaply, without a lawyer.
That's not how it worked in this case. We filed that one-page complaint seeking Spencer's contract, and the Tri-C Foundation responded by hiring a law firm. The Court of Claims asked for legal briefs, and Fox 8 retained attorneys. The foundation argued that it is a separate entity from Tri-C, the college, and therefore not subject to the Public Records Act. After a back-and-forth legal battle, the matter wound up before the 8th District Court of Appeals in this courtroom.
Tri-C Foundation has spent hundreds of thousands of dollars in recent years lobbying for the benefit of Tri-C. Now again,
well, it's its alter ego, right? I mean, it doesn't exist without Tri-C.
From our perspective, absolutely.
There is no question that Tri-C, the college, is subject to Ohio's Public Records Act. Here, the question for the judges was, how closely is Tri-C's foundation connected to Tri-C? Is the foundation what the law terms the functional equivalent of Tri-C, the college? The closer the two are connected, the more likely the foundation is subject to the Public Records Act.
The Tri-C Foundation has a specific and limited charitable mission, which is raising money to help and support Tri-C scholarship students.
The foundation's attorney stressed how the two entities are separate, including in some ways financially.
The Tri-C Foundation does not manage or hold any funds that are in the name of Tri-C, the college.
The judges asked several questions about how closely Tri-C and its foundation are connected, including the fact that the foundation's president, Megan O'Brien, on the left of your screen, is also the vice president of development for Tri-C, the college.
Even Ms. O'Brien, she says, I'm vice president, Tri-C Foundation.
She wears different hats, and importantly, the two entities
Doesn't that give you any pause about the test?
No, Your Honor.
If Tri-C didn't exist, there would be no foundation.
Potentially, if the foundation would have to change its mission or otherwise.
And its name?
Potentially, but just because it's
clearly its mission.
The questioning continued.
You can't just say all out of the blue, there's this foundation that's called the Tri-C Foundation.
You can, and it was created to be a charitable.
But without the college, there is no Tri-C Foundation.
The fact that the Tri-C Foundation supports what the government does does not.
It's its entire mission.
In a 3-0 opinion written by Judge Blackman, the court said, "We conclude that the Tri-C Foundation is the functional equivalent of a public office. Under the public records law, Scheel is entitled to the unredacted Spencer contract." And here it is. The Tri-C Foundation paid Octavia Spencer $150,500 to attend the presidential luncheon, plus first-class expenses. Her first obligation of this day started with a VIP meet and greet that included Tri-C President Dr. Alex Johnson. That was at 11:40 a.m. Her obligations ended at 2 o'clock. 2 hours and 20 minutes, $150,500. That's what the public record that is her contract shows.
It's critically important that people challenge denials of their public records requests so that the public can be more informed about how its government is operating.
A statement from Foundation President Megan O'Brien sent with the contract said, in part, that speaker fees are paid with private, not public dollars. The statement added that the Spencer event netted approximately $1 million for scholarships. So why not just say that you raised $1 million to fund scholarships at this luncheon? Why challenge the public records request and spend an extraordinary amount of money that likely could also go to scholarships on attorney's fees? We wanted to ask these questions and more of Dr. Johnson or Ms. O'Brien, but through a spokesperson, both declined to do an interview. This case may well make it easier now for people in the future to get public records in Ohio.
It should reduce barriers to getting a judicial determination that these types of records should be released. It's important because you want to know what your government is doing.
And if you want to know how much the Tri-C Foundation spent on attorneys to fight this case, that's tomorrow's story. Bill Scheel, Fox 8 IT.
It's one of first impression under this particular statute.
What judges call a case of first impression means a case that is setting the law in some fashion for the first time, which is why we believed it was so important to pursue this particular case.
But I think it's a very positive step for the taxpayer, and everyone's going to be citing Scheel versus Horton when they're arguing for disclosure.
The Academy Award-winning actress Octavia Spencer spoke at Kent State's commencement in 2017, receiving $100,000 plus first-class airfare for her appearance. Kent State, as a public taxpayer-supported university, readily released her contract under Ohio's Public Records Act. But when Ms. Spencer spoke just months later, here in a question-answer format at the presidential luncheon for the Cuyahoga Community College Foundation, Tri-C said it didn't have to disclose how much Spencer was paid. It argued its foundation was a separate entity, a private institution, not subject to the Public Records Act. We disagreed, and through our attorneys,
Tri-C, the college, has to report the foundation as a component unit on its financial statements.
Took the matter to court. We did so initially by filing a complaint through Ohio's Court of Claims, handwritten as required by law. It's a newer method that is supposed to make it easier and supposedly less expensive for all taxpayers to challenge the denial of a public records request. Our case became the first one filed this way to reach the 8th District Court of Appeals in downtown Cleveland, making the question of the status of the Tri-C Foundation a case of first impression.
The only issue that we have to determine is whether there's clear and convincing evidence that this is a public institution.
Attorneys for the Tri-C Foundation argued that it was not, and therefore we were not entitled to the contract showing how much Spencer was paid.
There's simply not clear and convincing evidence to overcome Fox 8's burden.
But the closer the Tri-C Foundation is connected to Tri-C the college, the more likely it is a public institution, a functional equivalent, as the law calls it. The judges question how close some of those connections are, including the fact that Megan O'Brien, on the left here, is both president of the Tri-C Foundation and vice president of development for Tri-C the college.
And the executive director is employed by the college as well as the foundation.
Separately, and she has separate duties to each organization, and she wears separate hats.
Fox 8's attorneys argued the close connections were obvious.
Famous United States Supreme Court case. You know it when you see it. And that's really what confronts this court today.
In a unanimous 3-0 opinion written by Judge Blackman, the court said, "We conclude that the Tri-C Foundation is the functional equivalent of a public office. Under the public records law, Scheel is entitled to the unredacted Spencer contract." Public policy expert John Plechnik says the fact that the case began with the new process that goes through the Court of Claims is significant.
So this is really new ground that we're breaking, and I think it's positive from the perspective of disclosure and taxpayers that the first major decision says err on the side of disclosure.
This is the Octavia Spencer contract. The Tri-C Foundation paid her $150,500 to attend the presidential luncheon, plus first-class expenses. In a statement attributed to Megan O'Brien, the Tri-C Foundation said speaker fees are paid with private, not public dollars, and that the Spencer event netted approximately $1 million for scholarships. We wanted to interview either Megan O'Brien or Tri-C President Dr. Alex Johnson to ask, among other questions, why try so hard not to disclose that you spent just over $150,000 if you made $1 million? But through a spokesperson, both declined interviews.
I think you're seeing more government agencies and municipalities try to use nonprofits to avoid disclosure, but the Sunshine Laws make it very clear that we have a right as taxpayers to know how our money is spent. And just running that public money through a private entity doesn't mean you have any less right to know what the contract was, how much was spent.
And in trying to keep us, and therefore you, from learning the value of the Spencer contract, the Tri-C Foundation spent an extraordinary amount on attorneys. In fact, more money than it spent to bring Octavia Spencer to Cleveland. These are copies of checks we were sent as part of the response to a new public records request we made for the legal costs incurred by the Tri-C Foundation or Tri-C to fight this case. We received copies of 18 checks, many running into the tens of thousands of dollars apiece. All total, the Tri-C Foundation, the arm of Tri-C that raises funds for student scholarships, spent over $236,000 of its money to fight this legal battle. Over $236,000. Try not to tell us it spent just over $150,000 on a luncheon where it claimed to make $1 million. So was that $236,000 money well spent? Hope Beck is a Tri-C student.
Probably not.
Because?
Because it should go to students who need it.
This case may have set a precedent, but Professor Plechnik hopes it's done even more than that.
If we can build off of Scheel versus Horton and build a culture of disclosure, it won't even be necessary for taxpayers to bring these lawsuits.
The impact on the law of this case will be measured over time. How much of a difference it will make, we will have to wait to see. Bill Scheel, Fox 8 I-Team.